Okay, friends, thank you for tuning in to the Bill Houston podcast. I just have to make a little adjustment on my. Oh, I'm a little bit dark. Sorry about that. Let me see if I can. And I've got a noisy dog that's barking nearby. I hope that you don't. Hope that dog barking doesn't. Hope it settles down in a minute. Okay, here we go, friends. So here's the deal. We have. Let me just. In the village of Endicott right now, we have this Verizon Master License Agreement that is on the table right now. Let me see if I can improve my lighting. There we go. That's a little bit better. And it's my personal goal to try to convince the village officials that we need to table this master license agreement due to many defects in this agreement. There are some very serious limitations and defects, and I'm very lucky to have Odette Wilkins on the line. And let me see if I can call up her. I have a little bio here. I had some technical glitches here at the start of the show. Okay, so let me read to you about Odette. Odette Wilkins has been a technology attorney for almost 20 years, having worked with multinational financial, entertainment, and technology companies. She is heading up Hardware Broadband Incorporated with an exclamation mark, a nonprofit startup whose mission is to raise awareness of 5G hazards and to promote a superior technology, which is fiber optics into the home, which is faster, safer, and more secure. Okay, and with that, I'm going to see if I can bring Odette onto the call. Odette, can you hear me? Hold
yes,
on.
I can hear you.
How about now?
Oh.
Odette?
Yes, I can hear you, Bill.
Try one more time.
I can hear you, Bill. Can
Okay,
you hear me?
very good. I can hear you now. I had to push some buttons on my mixer. So God bless you. Thank you very much for coming on the show here. And I'm just going to call up my my notes here. There's a couple of things that I really want to. I just want to kind of set up a framework for the show, if that's okay. I do want to discuss. Sure. I want to discuss a little bit with you because people don't. This is a brand new thing. Nobody really understands this, and I certainly didn't just a couple of months ago. And I'm fairly technically and legally savvy for a layperson, but so this is a brand new technology, and there are certain very serious impacts to human health and to things like birds and insects and pollinators. I would like to talk about that. I want to talk a little bit about the regulatory scheme that's been set up, and I know this is something that you really know a lot about. And then I want to talk about, what is the role of local municipalities in this regulatory scheme, and then what can communities do that are sort of either opposed to this outright, or they feel like, there needs to be a little kind of a pause or a timeout until we all come up to speed and learn about the issues. Does that sound okay to you as to kind of an overall scheme of our talk today?
Sure, that sounds good.
Okay. So let's just real briefly, and I know the substance of this is going to be the regulatory scheme, but let's talk a little bit about what are some of the impacts and the concerns that people have about 5G coming into their communities. Can you talk about that a little bit?
Yeah, sure, Bill. First of all, I just want to correct you a little bit. Our corporation, our nonprofit corporation, is Hardwire Broadband.
Oh, I'm sorry. Hardwire. I think I'm sorry. Go ahead.
Yeah, because it's hardwire the broadband, because you don't really need a lot of wireless infrastructure, but we can use a lot of wireline infrastructure, and that is what our focus is at Hardwire Broadband Incorporated.
I'm sorry if I read that wrong. Very good. Thank you.
That's quite all right. And I just want to say that this is all about 5G, and there's been a lot of industry hype about 5G, how it is so much faster than what we have now, and wouldn't it be great for your refrigerator to be communicating with your microwave?
Right.
And wouldn't you like to have faster download speeds? Now, frankly, all of my friends I've asked, do you want faster download speeds? I said, no, my download speeds are fine. Now, when you look at 5G compared to fiber optics, now fiber optics carries wavelengths at the speed of light.
Okay, wait, before we start talking about fiber optics, let's stick with, just for the beginning, just to orient people, what are the health concerns or what are the other concerns about 5G, and then we'll talk about the solutions.
Okay. Let me just say that I'm not really sure why anybody would want 5G, because fiber optics has upload speeds that are about 5 times faster than 5G, and download speeds, I think, that are about 10 times faster than 5G, or at least that's what I've heard. So, fiber optics is so much faster and safer. It doesn't steal out radiation. It's so much more secure. So, frankly, I don't know why anybody would want 5G or why 5G is such a big deal.
Before we talk about the solutions as being hardwired with the fiber optics, let's orient people. Why are people all over the world concerned about 5G? Let's talk about the concerns first, then we'll talk about the solutions. Why are people worried about 5G?
Okay, so the concerns are that since the 1970s, there have been scientific studies that have been conducted by the government and by independent scientific communities showing that radiation levels, even far lower than 5G, have caused tumors, cancers, DNA damage, heart arrhythmias, nausea, headaches, autoimmune disease, and much more. And these are either shown in laboratory animals or in humans. And children are much more affected by this type of radiation because they don't have a sufficient barrier. Their skulls are still not formed, so the radiation penetrates more deeply into their brain.
Mm-hmm.
And we certainly want that. And a lot of these 5G antennas are cropping up around schools and nursing homes and medical facilities, as well as people's residences. And there was one residence, I know that in California, where there was a small cell whose wavelengths were going straight into the bedroom of these 2 children, and these 2 children became very ill. This you can see on Scientists for Wired Tech. And that's very disturbing, and that's not the only instance in which people who were close to the tower were sick. And that's the problem. The problem is that this is basically an environmental hazard. And that is what the insurance companies have designated this type of radiation to be, and it's considered a pollutant. There are reinsurers who refuse to insure on the basis of wireless communications because of the potential for physical harm. When you say
insurers, are you talking about insurers for like home insurance? What kind of insurance are you talking about?
Oh, sure. I'm talking about insurance for physical injuries. If somebody gets sued by a third party because they were physically injured they claim they were physically injured by this radiation, then that is the type of insurance I'm talking about.
You're talking about
usually general commercial liability. You're
talking about the insurance that's held by the carriers.
Exactly.
Okay, I got it. Go ahead.
But then again, you have to sit the carriers, for the most part that I understand, they cannot even obtain this insurance. And anytime they put into a contract saying that they are going to indemnify the village and they're going to insure for physical injury,
mm-hmm.
well, there's usually a pollution exclusion. And the pollution exclusion says that they're not going to cover for any kind of injuries due to this type of radiation or electromagnetic frequency, which is another way that it's called. It's EMF. So they're going to be providing a pollution exclusion. So the insurance that would be provided in the agreement basically would not cover for the type of physical injuries that people would be coming after the city for. And so anytime you have an insurance requirement, you have to make sure that there is a waiver of the pollution exclusion. So
okay. Now we're getting into the technical details about this particular license agreement, but before we even do that, or in general, what these master license agreements generally contain, before we even get into that, that's like the third segment. So we've talked a little bit about the very serious human health impacts, and there is voluminous data on radiation hazards, electromagnetic fields, EMF, also radio frequency radiation hazards, which they tend to say is non-ionizing, and it's only heating hazards. It can heat biological tissue. But the question of whether this millimeter wave radiation is non-ionizing or not is, from what I've read, it's up in the air. In other words, this might actually be cancer-causing, and it might actually damage human DNA. So there's very, very serious health concerns that people have, and concerns about birds and insects and things like that. And if we destroy the pollinators, it's kind of like game over for the planet. Now, what I want to talk about a little bit now, before we get into this whole at the local level, I want to talk about, let's just talk for a minute or two about the overarching regulatory scheme. Who's regulating this? Let's talk about the federal government. Let's talk about Health and Human Services, HHS. Let's talk about the EPA. Let's talk about the FCC. What kind of regulation is the federal government doing on 5G?
Oh, okay. Yes. Well, the FCC has put forth a number of rulings in order to expedite the deployment of 5G, and in order to streamline the authorization process down to the local level. And they've done recently they also did in 2018, and they're just trying to accelerate 5G. So that is what they're doing. Now, these rules are really just rules that of their interpretation of the Telecommunications Act. There are two specific provisions that reserve the right to the local government for any types of telecommunications equipment. There's Section 253, which reserves the right of local government to manage the public rights of way. So as a local government, you don't want to give away your right to manage the public rights of way, because the Telecommunications Act gives that to you, as well as Section 704A of the Telecommunications Act, which reserves the right of local government over, and this is very important, over the placement, construction, and modification of personal wireless service facilities.
So we
local government has.
Go ahead.
So local government has a lot of control, and unfortunately, for the providers and the carriers and the wireless carriers, they may not like the fact that the law guarantees the states and localities a right over the deployment of any kind of wireless technologies as well as wireline technologies. But that doesn't entitle the wireless companies to take any form of preemptive action against the local government. Okay,
so let's unpack that, because that's a really huge thing, and that's something that, I really think we need to make sure people understand this. So first of all, the Telecommunications Act of 1996, boy, a lot of technology has changed since 1996, hasn't it? So, I question right there whether the 96 Telecom Act, should be completely appropriate or not, because so much has changed. You said the first section that governs local rights of way, that was Section 253?
Uh-huh.
And then 203, I think you said 203A governs the placement of the poles. Is that right? 203A?
It's Section 704A.
Sorry, 704A. And would you say that is that what are either one of those what could be considered as zoning, that this is a zoning, local zoning jurisdiction?
Yes,
But
absolutely. And the local government has to have robust local zoning laws and regulations regarding the siting requirements of small cells as well as other wireless facilities, so that they can effectively regulate the placement, construction, and modification of these personal wireless service facilities. That's exactly right. And if you have to, in order for now these rights are reserved to the local government by the Telecommunications Act of 1996. But the local government has to claim jurisdiction over this area by promulgating and passing legislation and zoning requirements specific to the locality. So that is very important. Part of the regulatory scheme there is that if a locality denies an application, and they have the right to deny an application, the Telecommunications Act requires that denial is substantiated by substantial evidence. And in order to do that, you have to have a good law that is applied across the board fairly and on a competitive basis across all wireline and all wireless carriers. If you have that, your denial is based on a good, robust requirements, rule or regulation or act or zoning requirements, then you can provide the substantiation that is required under federal law.
Awesome. So now I want to go back, and you mentioned something about preemption, because I think what I'm hearing from, we had a presentation from this guy from Verizon, Greg Hanley, I think is his name. And I've tried calling him, emailing him. I reached out to him 3 or 4 times to talk to him. He's completely in the bunker. He will not talk to me. But what he said to the village, he did a presentation at the last village board meeting, and he gave us the impression that all regulation, except for this very narrow couple of things for rejecting a poll application having to do with aesthetics and different things, he said all local regulation is preempted by the 1996 Telecom Act. And you just mentioned preemption, so help me unpack that a little bit.
Okay, so that's not entirely correct, because under the Telecommunications Act there is preemption, but the preemption only refers to telecommunications services. That is your cell phone coverage. It does not relate to broadband internet services. 5G has been acknowledged by the industry to provide broadband internet services. Now, it may improve some cell phone coverage, but if it's for broadband internet services, that is not preempted by the Telecommunications Act. The Telecommunications Act is only there to make sure that people can get a call on their cell phone or on their copper line. That is it. The TCA does not preempt broadband internet services, and that is what 5G is.
Thank you. Yeah, go ahead. Keep going.
5G is really not there to provide you with cell phone coverage. Now, it might improve it in some areas, who knows, but primarily it's so that your refrigerator can talk to your microwave. Now, what does that have to do with a cell phone service? Nothing. But these carriers, these providers want their own broadband preemption, and it's totally unsupported by the Telecommunications Act. See, under the Telecommunications Act, the telecommunications services have to be functionally equivalent services. 5G is not a functionally equivalent service because it is not really meant for cell phone coverage. It is meant for broadband internet services, not regulated, not preempted.
So it seems like, this is I appreciate you spending a little time on this narrow issue, because I think this is a huge thing. So it seems like to me that the telecom companies are kind of doing a little switcheroo, a little sleight of hand here, that they're taking this broadband internet technology that really has nothing to do, it's wireless data. It's not wireless phone service, it's wireless data services. And they're trying to fold it in, and they're trying to see that there is regulatory authority in the 1996 Telecom Act of this wireless broadband, and you're saying it's not there.
It's not there, and yes, exactly, and it is not there. The Telecommunications Act only refers to ensuring that everybody has good telecommunication service, and that is cell phone coverage. That is not broadband internet services that 5G is providing.
Now, has that been decided by the courts, or and what is the FCC says something like it's advisory only? It's what's the language there?
FCC has provided rules, and the rules are supposed to interpret the law. And the rules are trying to accelerate the deployment of 5G. Now, basically, what is happening is that because 5G is not a functionally equivalent service to telecommunication services, because it basically deals with broadband internet services, there is no preemption.
No preemption. So, all right. So, EPA, does EPA regulate 5G in any way in terms of, EPA handles environmental pollution. So does EPA regulate 5G, yes or no?
No, it's the FCC. FCC has emission standards, and from what I last read, I believe the guidelines say that the emissions are supposed to be less than 1,000 watts. And if it's more than 1,000 watts or whatever the particular unit of measurement is, then it triggers an environmental review. And as a matter of fact, under the Kitoa versus FCC case, which was brought in front of the D.C. Circuit Court of Appeals, the D.C. Circuit Court of Appeals decided in August of 2019 that when the FCC decided that the deployment of 800,000 quote-unquote small cell antennas for 5G did not require an environmental review, the D.C. Circuit Court of Appeals said that was not a logical decision, and it was arbitrary and capricious.
Okay.
So the D.C. Circuit Court.
So real quick, so I don't want to interrupt you, but real quick, when you say environmental review, because we're talking about the D.C. Circuit, I'm assuming you're talking about NEPA, the National Environmental Policy Act. Is that correct?
Exactly. That's the National Environmental Policy Act, which requires environmental review and environmental assessment for anything that's going to have an environmental impact. And the court was really incredulous when the FCC said that 800,000 of these antennas deployed around the United States would not have an environmental impact. The court, I think, was pretty aghast at that.
Wow.
And they sent it back to the FCC to think about it again.
Mm-hmm.
And now New York State has its own environmental review called the State Environmental Quality Review Act.
Wait. Before we talk about SECRA, let's stick on NEPA really quick. Has anyone, has the FCC or any federal agency? So what I heard was, and I just want to, in my own head, I have kind of like these bullet points. Okay. You're saying FCC basically is rolling out the red carpet. They aren't really regulating this except for these certain power requirements, which I think we need to talk about. We need to drill down into those power requirements, because what I heard on a call on Sunday that I was on, this New York City virtual tour, is that some of these power readings that they have were like 6 orders of magnitude higher than the FCC level. Is that right? Like 1 million times higher, and it has to do with average measurement versus bursty. These spikes. It's pulse. I think it's pulse coded modulation. It's very bursty, and the bursts are super high power. And then there's dead spots in the middle, and they're taking the average. But in reality, if we look at the bursts, they're way over the FCC limits. So I just wanted to say that. But so FCC really is taking a pass. The EPA is taking a pass. What about Health and Human Services? They're not doing anything, right? The federal HHS.
Well, no, I don't think the HHS has jurisdiction over this
No,
area.
no jurisdiction. Okay, so all the federal government's taken a pass. Now, has the FCC or any federal agency been involved in a NEPA review of these 800,000 planned small cell 5G towers that are going up all over the country? Has there been a NEPA review?
Well, if there has, I certainly don't know of any, because the FCC is trying to deploy 5G even faster.
Oh my God.
Yeah.
Mm-hmm. So no NEPA review. All right. So I think we've covered the regulatory scheme. Do you want to say anything about the regulatory scheme at the federal level, and then let's talk about the state level? Anything? Have we exhausted the federal level in a brief discussion?
Yes, I think. Yeah, I think we're ready to go to the state.
The federal government is taking a pass. So what about the state? So at the state level, here are the agencies that I can think of that might exercise some kind of regulatory control. We have the Public Service Commission, the DEC, and the New York State Department of Health. I'll just tell you, I foiled the Department of Health, and I said, give me all your data on the health and safety impacts of 5G, and they say, no records meet your request. So what about the DEC, and what about the Public Service Commission?
I don't think they, from what I understand, I think they've also taken a pass. I think that they don't think that it's in their jurisdiction.
Mm-hmm.
I don't think that they think it's in their jurisdiction. However, I do want to say that the city of Rye, New York, won 2 lawsuits on the federal and state level because they rendered a positive declaration under the State Environmental Quality Review Act with respect to Crown Castle and its small cells to be deployed in Rye. And they gave a positive declaration saying that there needed to be an environmental review of these small cells. And what happened is that the federal judge agreed, and so did the state judge. And it supported the city of Rye rendering a positive declaration.
So let me unpack that really quick. So seeker is for people that don't deal with this stuff every day. So we have the National Environmental Policy Act. That's the federal environmental review. In New York, as you started to say before I interrupted you, in New York, we have the State Environmental Quality Review Act, which people call seeker or SECRA. So whenever there can be a negative declaration, which means no environmental impacts, and then there's a positive declaration, which means there are environmental impacts, and that triggers an environmental impact statement. Is that correct?
Yes, an environmental review.
Exactly. And then, so one thing I'm curious about, if this was, I can understand this was litigated at the state level and the federal level. I'm a little curious that a federal judge would have ruled on what's the legal term? Pendant, a state claim. Why would a federal, just for my own curiosity, why did the federal judge rule on a secret determination?
It was because Crown Castle sued the city of Rye in both federal and state court.
Got it. Okay. So basically, the DC Circuit, or was it DC Circuit or was it Second Circuit?
The DC Circuit Court of Appeals in Ketowa determined that it was an arbitrary and capricious decision on the part of the FCC to make a determination that 800,000 small cells deployed in the United States would not have an environmental impact.
Okay, but concerning the city of Rye, I'm getting a little mixed up now. City of Rye went before. This has to do. The city of Rye, basically, the determination in the city of Rye case was to say that a seeker, a review under the New York State Environmental Review was appropriate. Is that what the determination was?
Exactly. And the mayor of Rye said that the order recognized the importance of a diligent review process that includes potential environmental impact of quote-unquote small cells.
Okay. All right. So we have some successes here in terms of the right of somebody, in this case, we would be talking about the Village of Endicott, to demand an environmental review. So that's awesome. So let's talk about let's talk about a little bit more about. I think you had a look at this Verizon Master License Agreement. And I know you want to speak more in general terms, not necessarily specific to this, but what kinds of things do these telecom carriers, when they come into a local municipality, what kinds of things do they put in these franchise agreements, and how? I mean, can we talk about that a little bit?
I'm sure, but do you mind, Bill, if I just give a little bit more framework, background on the on the regulatory scheme? Because
Please.
I think there's a little bit.
Please.
Okay. So the other part of the regulatory scheme under the Telecommunications Act is that the carrier, in order to have a right to come in, must show a significant gap in cell phone service. And if there's no significant gap in service, there is no preemption. And the carrier must show that their means of remedying such gap is the least intrusive means possible. Those are the two requirements of the Telecommunications Act, and that is how the Second Circuit, which New York is subject to, has interpreted the Telecommunications Act. So you have to have a significant gap in service, and that is the only thing that provides preemption. If there is no significant gap in service, there is no preemption, and it has to be the least intrusive means possible. So those are the two things that have to be met. The other thing is that I just want to say that with respect to this significant gap in service, Cambridge, Massachusetts won its lawsuit against Extenet. And what Extenet wanted to do is that they wanted to install 5G small cells. Now, Cambridge has a very robust site polling requirement and has a specific policy specifically for the small cells. And the court there, and that was the state court, I believe that was the state court, held that Extenet had a burden of proof and failed to meet it. And it states, where Extenet's complaint in its original application failed to show the existence of a coverage gap, it is impossible to infer that the denial of Extenet's applications has the effect of prohibiting the provision of wireless services. And so the court ruled, let me say something else. The court ruled Extenet did not allege sufficient facts to show that the denial by Cambridge could in any way inhibit the provision of service because there was no gap in service.
Mm. Oh, so that prohibiting a gap in that's a requirement of the Telecom Act, right? That the local municipalities cannot do something that would prohibit. I'm sorry, I'm struggling with the language here.
Okay, so basically, the Telecommunications Act wants to make sure that localities don't inhibit the provision of service. That they don't, that if there's a gap in service, that they allow the wireless companies or wireline companies to come in and to provide the service.
So,
but what Cambridge, in the Cambridge case, they denied the application because Extenet failed to show that there was a gap in cell phone coverage.
Got it.
No gap in cell phone coverage, no preemption, no right to come in to a local a municipality. No right.
That's incredible. So the local municipality can deny a poll application if the telecom carrier does not show that there is a gap in coverage. Now, my question is, so in our case here in the Village of Endicott, we don't have a poll application right now. All we have is this master license agreement that they're trying to My reading of the master license agreement looks like that we are agreeing by contract to waive our rights of remedy. So that raised the hair on the back of my neck a little bit. I'm like, hey, if the Telecom Act, waives our right of remedy, then that should stand on its own. Why do we need to agree to that in the contract?
Well, actually, Bill, the Telecommunications Act gives a lot. They reserve the right to the local government to manage the public rights of way, so long as it's done fairly, competitively, and in a non-discriminatory basis. And it reserves the right to local governments for over all decisions regarding the placement, construction, and modification of personal wireless services. Now, there's no reason to limit your rights in Endicott or Binghamton or Alfred, New York, or Buffalo or anywhere else. There is no reason to limit the rights that the Telecommunications Act already gives you. If you're entering into an agreement, that's because the carriers or the providers want to limit your rights. Now, why would you want to do that? Now, I'll tell you, under the regulatory scheme, just to go back to it just a little bit, is that there are 3 limitations that the state and local governments are subject to. And that is that they shall not unreasonably discriminate among providers of functionally equivalent services. Okay?
Mm-hmm.
So that if there are other carriers who are going to be want to provide wireless services, telephone service, that you're not going to discriminate between, you're not going to discriminate in, say, Verizon over Spectrum or Spectrum over AT&T or AT&T over T-Mobile. You cannot do that under the Telecommunications Act. You have to treat them all fairly and without discrimination.
Mm-hmm.
The second limitation is any denial of an application must be in writing and supported by substantial evidence contained in a written record. That means that in order to sustain your denial of an application, you have to have a robust ordinance and robust siting poll requirements. And I'd be happy to share with you the public policies that Cambridge has put forth, because they have a very robust set of policies for small cell deployment, and it was upheld.
So this. Go ahead. Third one. Go ahead.
Third limitation is that there can be no regulation on the basis of environmental effects of radio frequency emissions to the extent that the wireless facilities comply with FCC emission standards. Now, you had said, Bill, earlier that some of these emissions are 1 million times more or whatever than the FCC permitted standards. What happens is that in an application, usually a provider will indicate what the average emission level is, as you said. They don't tell you what the peaks are. And as you indicated, this is pulse-modulated microwave radiation, which means that it pulses very high at certain points at peaks, and it goes low, and what the carriers provide you is the average when it goes well above the FCC emission levels. Now, there's an attorney I know who works in this area, and he said that when an engineer was sent out around different parts of a state or different parts of the country, the engineer found that the emissions were anywhere from 800 to 1,200% higher than the FCC permitted emission standards. The problem is that the Telecommunications Act, neither the Telecommunications Act nor the FCC requires that a provider measure its own emissions. So they're just going on the carrier's word for it. So it's basically the fox guarding the hen house. You don't have anybody taking the emissions. And there isn't a requirement of the FCC to go around and determine that the emission standards comply with their own guidelines. So the first line of defense is always the local government. It is the village of Endicott. It is the city of Syracuse. It is the city of Binghamton. You are the first line of defense. Without you, there is nothing. And the officials of every single locality, including in New York City, is to protect the health and safety of its residents. And so if the providers are spiking, if their emissions are spiking above the FCC limit, then they are not in compliance. And when they're not in compliance, there's no preemption.
So
go
ahead.
Can I just say something?
Absolutely.
I've read in New York City, we have a wireless ordinance, and it states that if the providers are in breach or in material breach of the franchise agreement, in other words, they're not in compliance with the FCC emission standards, their franchise can be terminated.
So here's the troubling thing that I have about this kind of a regulatory scheme, Odette. We are speaking with Odette Wilkins, a technology attorney with, tell me the name of Hardwire Broadband Incorporated. And she has been working on the, shouldn't characterize it as fighting, but working on education and legal aspects of this 5G rollout in New York State for at least a couple of years, my understanding is. And very privileged to have you on the show. Go ahead.
Actually, Bill, I'm a newbie. I only started on the 5G issues back in June of this year.
Well, you've really come up to speed very quickly, and I'm very grateful for the assistance that you're giving us. So you mentioned this Cambridge, the win on the Cambridge. I mean, I think this is a nice segue into the final segment, and that is this, what kinds of things does a local municipality like the Village of Endicott, what do we need to do to prepare ourselves? You mentioned this Extranet case versus Cambridge, Massachusetts, that it was supported by this very strict local ordinance. I think you said that there's it's not only a siting for the poles, but also this very specific law or ordinance that dealt with small cells. Oh, this is what I wanted to, before I get into that, I just remembered what I was going to say. The problem that I have with the regulatory scheme, as you laid it out, is it seems like it's in other words, to prove that they're not in compliance, we have to let them build it out first, and then we bring our meters and we go, oh, look, and then we have to try to, I've been doing environmental work for years and years, and my feeling is, from what I've seen, is once they get their foot in the door, it's very hard to get them to actually turn off the equipment. Like, this could be compressor stations or pipelines or fracking wells or anything like that. Once they build it out, you're kind of screwed. So now it's up to, expensive lawsuits and things like that to say, look, they're out. Look, here's the meter. They're out of compliance. They're 6 orders of magnitude higher than the FCC limits. I mean, it's kind of, isn't it? It seems like it's too late by that point. It seems like there needs to be a way for local municipalities to I want to use the word preemptive in a slightly different context than what we were talking about. Preemption in terms of federal law preempting, tying the hands of local municipal officials. That's one kind of preemption. But I want to talk about preemptively, like putting up barriers before the fact. I mean, what can we do before? What can a local municipality? Can you dive into a little bit, though, about the Cambridge local laws that they had that actually protected them and helped to guarantee their rights before the court?
Well, it's pretty lengthy, actually. It's a very lengthy policy. I've never seen such a long policy before. I think it's 20 or 30 pages. And
well, just in a very high level, in a very, very high level terms, the local municipalities need to pass specific zoning laws and also just ordinances dealing, right?
Yes, absolutely. You have the reason why they won was because they were so robust and so specific in their requirements that it applied, because it applied to everybody. It applied to all the providers. You know, it's not just Extenet. It would apply to T-Mobile, to Verizon. It would apply to everybody. So under the Telecommunications Act, they are all being treated fairly. But the most significant thing is that they had in their policy that there has to be a significant gap in service. Now, even if they don't have it in their policy, a significant gap in cell phone service is already law in the Second Circuit, and we are in the Second Circuit. And Cambridge is actually in the First Circuit, but they also go by the gap in cell phone service. And that is why they won against Extenet, because Extenet could not show that there was a significant gap in service. Now, one thing they have to be careful of is sometimes the agreements don't even require an application to be provided, or the application is just pro forma, it's just rubber stamped. That's why it's so important to say that these providers must comply with your application requirements, your zoning requirements, your site building requirements, your small cell policy requirements, and there has to be, for there to be preemption, there has to be a significant gap in service. If they don't, that is a threshold question. If they cannot show a significant gap in cell phone service, there is no preemption, and they have no right to come in.
So I'll tell you, I've looked through the Endicott Village Code, and I'll tell you, we do not have a wireless policy. We don't have, there's some very, they mention, the definition of an antenna, but there's no substantive mention of it anywhere else in the code. We don't have. If you're telling me that all of the regulatory, I just want to summarize. You're telling me that all of the regulatory authority comes down to the local level. We have no local protection. We have no local laws right now specifically dealing with this issue. And Verizon has come in and presented the village and said, sign this master license agreement with no application for any particular antenna or pole or anything like that. Right now, it's, we don't have, so we're completely unprotected. I mean, what would you, just offhand, what would you say to a village official that does not have doesn't even necessarily need to be Endicott, but if you do not have a local law that's robust and specifically deals with these small cell towers and pole siting requirements, et cetera, would you say that such a village or such a municipality should engage in a contract with Verizon that sacrifices, or any carrier, let's say, that gives up their rights of remedy and circumvents the Telecom Act in various different ways? Should they sign such an agreement?
Absolutely not. I would not advise it of my clients. Let me put it that way.
Yes.
I would not advise it of my clients. And if the Village of Endicott are my clients, or any of or Binghamton, or Alfred, or Syracuse, New York, I would want to really negotiate a master license agreement very, very rigorously, because you don't want to give up whatever local control powers you have under the Telecommunications Act, and that's exactly what these agreements try to do. What I would suggest is there are attorneys who are far better at this than I am, because I'm still learning here, but there's a couple of attorneys that I'd like to mention, if I may, who can help.
Okay.
Andrew Campanelli, who is very good, and he deals with these issues, and Joseph Van Eaton of Best and Krieger. He represents the city of Rye when they won their two federal and state cases.
What was the name of his firm again?
Best and Krieger.
Okay, Best and Krieger. Yeah, very good. So now here's just a quick question. This is just an opinion, and I know that attorneys are bound by clients and things like that. But if Endicott was theoretically your client, or just off the cuff, your opinion, it seems to me, I'm going to say something and I just want your feedback on it. It seems to me that this master license agreement, and by the way, in this agreement, there's no limits to growth. There's no, like, our ultimate plan is to put 150 towers or 150 antennas in Endicott. There's no mention about what the potential growth looks like. This is one carrier out of presumably other T-Mobile, and these other carriers are going to come in and want to put in their redundant infrastructure. So without any kind of mention about power requirements or limits to the number of these facilities or anything, it seems to me that a master license agreement should trigger a type, I would call it a type 1 seeker, and a positive declaration, meaning just the master license agreement should require an environmental impact statement. Do you have any thoughts on that?
Well, yeah, there should be an environmental impact statement on this, and because it does have significant environmental effects on people, children, especially the elderly, trees, insects, pollinators on whom we depend for our food. On all of this, and particularly with 5G, since it is really not a functionally equivalent service for cell phone coverage, that I don't see how it's preempted.
And you said at the top of the show, I'm sorry, go ahead, finish.
I'm sorry, with all the industry comments to the contrary notwithstanding, I don't see how 5G is a functionally equivalent service under the Telecommunications Act, and I don't see that there's any preemption.
Got it. So we have the right to just flat out turn down a master license agreement or even a specific pole application because it's not preempted by the Telecom Act. So just to summarize, go ahead.
Yeah, I just want to correct that. I mean, you definitely have to have that's why you need to have particular ordinance requirements in order to be able to provide substantial evidence as to why you're denying it. You can't just simply deny it and make a conclusive statement and say that, 5G is not a functionally equivalent service and therefore you can just go ahead and just deny it just based on that. That is not supported by the Telecommunications Act. The Telecommunications Act would require, like the Village of Endicott, come up with substantial evidence as to why they are denying that application. So, and so that's why the robust pole siting requirements and wireless ordinances are so important.
So we definitely need to. So that's what I wanted to do. We've been on the phone we've been having this conversation for about an hour now, and I know I really want to try to wrap this up if we can. So to summarize, in terms of maybe the best practices for a village like Endicott would be, I would summarize it twofold. Number one, we need to have, before we engage in a contract which locks us in and basically gives over our public rights of way over to Verizon or any other carrier that comes along, we need to have, the two parts. One part would be we need to have this robust local ordinance that talks specifically about small cells, pole requirements, all that stuff. We need to have that. And then the next thing is, I would say, is that before we pass any kind of a master license agreement, there needs to be a robust environmental impact statement that looks into things like human health impacts, and also, what does the rollout look like? What's the limits of growth? How many? We have no idea. An environment, you can't do an environmental impact statement unless you know the scope of the thing that you're doing, and there's no indication in this master license agreement that I can see as to the scope. It's just like, we're just going to do this thing, and just sign here, and we are completely unprepared, both technically and legally. And I just feel like we're getting bullied by these billion-dollar telecom companies. So would you agree then those two things, that number one, we need to have the robust local law that specifically governs these small cells. And then the next thing is we need to have an environmental impact of any theoretical master license agreement before signing it. Would you agree to both of those?
Yes. The first one is it would be a robust local ordinance for all communications, not just wireless and small cells. It really should be an ordinance that covers wireline as well as wireless communications.
Got it.
Because one of the things that the TCA requires is that the providers are treated fairly and competitive basis. So you have to make sure that your laws comply with the TCA. Once it's in compliance, you can put in the necessary requirements for your locality. But it has to be done in a fair and competitive manner in order to meet muster with the Telecommunications Act. On the second thing is that it's usually part of the application process that then there would be a determination by the local officials as to whether or not an environmental impact statement is required under seeker, and if there's a positive declaration. So the declaration comes after the application is submitted, but the application also has to be robust. And it also has to ask a lot of questions and ask why, if the applicant is saying that there's not going to be an environmental impact. Now the seeker becomes very important, especially if there hasn't been a NEPA review. Therefore, that's why the local government is the last line of defense. And that's how the local government can apply their jurisdiction. Mm-hmm.
All right. Well, thank you, Odette. So would you say we've covered it? Is there anything else? In other words, so what should any other advice about what a local municipal official should do? And then if you want to take this on, there's this follow-up. The follow-up would be, just a citizen like me, what should I be doing to best help my local municipality get prepared for this? And then just any final thoughts that you have. And I think we need to, an hour is quite a lot to ask people to endure. But I really, really appreciate this. We really dove down into the details. I know this is a real wonky discussion for a lot of people, but I think it's super important to get into these details that we covered so that we can be prepared and educated. And this is a brand new thing. Very few people are knowledgeable about this. I'm very pleased to have connected up with, I think it's New Yorkers for Wired Tech is kind of this ad hoc group. I don't know if it has any official structure or not, but I'm connected up to it, and also for your organization. So any just final wrap up that you have about how should a local town or village official really prepare for this? Just to sum up, and then what can the people do?
Okay, first, good questions. First of all, the officials should get attorneys who are experienced in this area. These agreements are written very much for the industry. They're industry prone agreements, and what you want to do is you want to have, as an official, the advice of attorneys who are knowledgeable in this area. Joseph Van Eaton actually advises municipalities, particularly in the area of telecommunications, and I guess that's why he won the Wright case. And Andrew Campanelli is also excellent, and he also wins a lot of his cases as well. So they would be really important. It's important to get really good counsel before entering into any agreement. And also before even discussing an agreement, I would say that it would be good to actually see a copy of their insurance policy with a waiver on the pollution exclusion. If they cannot produce that, then I don't see how you can actually proceed if they're not going to have the insurance to cover the physical injuries from radiation. Mm-hmm. But that's a question for the local officials to decide. But that should be, there should be certain threshold questions, and perhaps that should be one of them. And in terms of individuals, I think it's important to stay very much engaged, understand what 5G is all about and the harms that it is doing. I know personally of people who have been physically harmed by 5G towers that have been placed on top of their heads and on the rooftops of their buildings, and other people as well. And it's important for the officials to know that the individuals, the constituents, are going to support the officials if the officials deny an application. The officials cannot stand by themselves. They have to be supported by their constituents, and an informed constituency is going to be much better in the long run, and you'll have a much better result, because then you can also help to educate your officials, and the officials will know that that this is what their constituents want.
So I just want to say really quick, if anybody has any questions, especially if you are a town or village or a municipal official, if you have any questions for Odette, put them in the chat right now. Okay, so one just popped up. Put them in the chat right away, and we'll try to get to a couple of questions here before we let Odette go. And I'm very, very grateful. God bless you so much, Odette, for all of you're donating your valuable time to help us out in little lowly Endicott. I so appreciate you and your work here. We have a question from a town board member of the town of Union. So the village of Endicott sits totally within the town of Union, so there is some overlapping jurisdiction. This is from Heather Staley, and she says, is there any safe location for a 5G tower?
That's a good question. Usually, cell towers have been located miles and miles away from residential areas, so that people are not as affected by the radiation. For 5G to work, it has to be very compact. It has to be close together. About every 100 or 200 meters, I understand, there has to be a 5G cell tower, which means that it has to be in very concentrated areas right next to people's residences. And in New York City, they're as close as 10 feet from someone's window. That is quite dangerous, because 5G can really put out a lot of radiation. And for 5G to work, you need a lot of densely placed antennas. And so there really isn't a safe way of placing 5G. And if there is, you may want to ask an engineer. But because 5G, the 5G signals become very attenuated in longer distances, they have to put additional 5G antennas every 100 or 200 meters in order for it to work. And even if it's, 300 or 400 meters or 500 meters, that's still very close to the residences. And many times they're about even 60 feet away from the residence, and people have been getting sick. And that is what I have heard. So is there a safe place, a safe distance to place 5G? Not that I've seen, but perhaps an engineer might be better suited.
So she had just a follow-up comment. She said, in the town of Union, they put regular cell towers basically in the backyard of homes at the edge of town before I was on council. So so it seems like you're indicating that because of the technological differences with 5G, it is, and because of the physical characteristics of where they put these towers, would you say that 5G is inherently more dangerous, or there's a greater chance of human health impacts? Or would you say that even 4G and the earlier wireless technologies are just as dangerous? How would you compare 5G, the danger and the hazards, compared to the older style cell towers?
Well, I can tell you that based on what I've read from the scientific studies and summaries of the scientific studies, radiation levels at 2G and 3G have caused all of the litany of problems that I mentioned at the beginning of the program. the tumors, the cancers, DNA damage, heart arrhythmias, and other things. So 5G actually has not even been tested. And that's the problem with 5G. Senator Blumenthal in D.C. had asked the industry representatives, have you done any studies on 5G? And they all said that they're not aware of any. So Senator Blumenthal said, okay, so then we're flying blind here as far as health and safety are concerned. Bill, we're flying blind. There are no studies for 5G, and 5G can reach radiations at a far more powerful level, and because they have to be so close to people's residences, it's going to affect people even more based on the scientific studies on the lesser radiation.
So, and I brought this up. I did a little. I thought it was going to be a 5-minute promo, and it turned out to be a 20-minute promo before we did this show. But I brought up the fact that one of the things that concerns me is because what are we all going through right now worldwide? We're all under 7.7 billion people. We're all under lockdown right now. Why? Because of the big scary death plague virus. And but I've done research into that, and what I found was there was not really a proper epidemiological method followed, because that would have involved looking for alternative hypotheses, studying alternative hypotheses to the virus hypothesis. Okay, so Wuhan, we have 2,000 feet from my bedroom window, there's cited potentially to be cited a hazardous waste incinerator that I've been fighting for the last year and a half. And so I've been in Wuhan, China. They have notoriously bad air pollution. They have a lot of incinerators. Why didn't they jumped right on in the matter of weeks. They said, oh, we got it. It's a virus, and here it is. Here's the genetic blueprint of this virus. They never looked at alternative hypotheses such as air pollution. And I just want to mention this is like a forbidden topic. I hope YouTube doesn't take my video down for even mentioning this. But prior to this outbreak of people coming down with pneumonia, that's how they described this corona outbreak in Wuhan, China. It was pneumonia, which is flu-like symptoms. Just prior to that, and I'm sure you're aware of this, they turned on 10,000 5G towers, 10,000 5G antennas. They turned those all on, and all of a sudden people started getting sick with flu-like symptoms. And oh, by the way, what's the next city in the world with the highest casualty rates? I would say it's New York City. What happened in New York City? Oh, they just turned on 8,000 towers and people started getting sick. So, this is, and you just mentioned, this has never been studied. This has the human health impacts of 5G has never been studied, and the FCC is working on studies that are, what's 96, over 20 years old. The FCC is working with health studies that are 20 years and radiation power level standards that are 20 years obsolete. This is crazy to me. It just seems like it's like a death way. It's like if you ask a mad scientist from a James Bond movie about how to kill people in an efficient way, and he pulls out a pad of paper and starts sketching. Here's what we're going to do. We're going to blast this pulse modulated millimeter wave radiation into people's homes at 6 orders of magnitude higher than acceptable levels. It just seems like it's a suicide pact. What are we doing? It seems insane.
I got that, Bill, and people are suffering here in New York City right now, and I know people personally who are suffering. And what happens is with the radiation, it definitely affects your immune system, and that is what scientific studies have found for those levels of radiation that are less than 5G. Because again, there have been no studies on 5G. So we're basically, I don't know, maybe we're all guinea pigs.
I think we're guinea pigs
Because-
in a giant science experiment that we're all and we're all inadvertent. It's not. It's like we didn't even volunteer for this. This is being rolled through our communities, and we're being convinced that we don't even have any right to say no.
Right, and exactly. And so you brought up a very important point, and that is the issue of non-consent. And under the Nuremberg principles, after World War II, after the concentration camps and the Holocaust, nations have adopted those Nuremberg principles, which basically said you cannot experiment on an individual without their consent. And if we look at 5G being untested, is that the grand experiment? And have we gotten consent? So we have a problem here. And you also mentioned the antiquated guidelines of the FCC. The Children's Health Defense, that's headed up by Robert Kennedy, is now suing the FCC because their safety standards are so antiquated. They were back in 1996, and does not take into consideration these, even 5G, because I don't think 5G existed at the time, or if it did, it wasn't part of what people were receiving. But they are suing the FCC in order to revise their antiquated health safety standards. Now, look at it this way: the FCC was not an agency that's concerned about health. It's supposed to be like the EPA, that's concerned more about health, but somehow they got taken out of the picture, or the FDA. Somehow they got taken out of the picture. And the FDA did come out with a study, it was a national toxicology report that the FDA commissioned. And in 2008, they did find in laboratory rats definitive evidence of cancers, tumors, and DNA damage.
My God.
So, and that was on, I believe, 2G and 3G. So I can't even imagine what 5G does, and to have it so compact and so close to each other and so close to people's residences, that's what it's required in order for 5G to work. 5G is not going to work if it's 5 miles away. And why go for 5G? Why not fiber optics? That's how we started the segment. 5G is much slower than fiber optics. If we're looking at high speeds, we want high upload and download speeds, and we want our refrigerator to talk to our microwave. Why not use fiber optics? We don't need the Wi-Fi. We don't need the 5G. Fiber optics is faster, safer, doesn't spew out radiation,
and it's cheaper.
And
it's lower tech. It's less power intensive. It's just you're right. It makes so much more sense. This seems like this is insane. But why do we need it?
Yes, and so the thing is that since we are experiencing this pandemic, and people's immune systems are being compromised by this pandemic, why have the added irritant of radiation that is going to compromise one's immune system? That's already been established by the scientific studies all along. So why introduce something in the middle of a pandemic when people are trying to get their immune systems up, when this can actually damage their immune system according to the scientific studies?
Crazy. It's just crazy. Odette, God bless you. I adore you. I am so grateful for your help with little old Endicott. I can't express my gratitude to you enough, Odette, and I don't know how I can repay you, but I'm going to do my best to try to, help you in your endeavors, and in any way that I can, you can count on me. And I'm so grateful. This has been just a riveting and jam-packed informational session I hope it's going to be of use to the community that I live in, and also to our local town and village officials here. I hope people send this to the Town of Union, to the attorney, to the other Town of Union board members, to the Village of Endicott, to the trustees, to the mayor, village manager, the village attorney. I hope everybody send this video around, send it out, because this is critical information. And once we sign this Verizon master license agreement, we are going to be locked in. If we don't do an environmental impact statement, if we don't get our local ordinance in place beforehand, we are going to have no legal rights. Our rights are going to be waived. So call the village trustees if you're a resident in Endicott, if you're in the Town of Union or in Johnson City. Call your representatives, your legislators, and get them to listen to this video and to take appropriate action with your town and local officials. Odette, last word. I'll give you the last word. Is there any final comments that you want to make? And thank you so much for this conversation.
Oh, absolutely. It's been delightful, Bill, and I'm so happy that you invited me to talk. I do want to say that whenever looking at a franchising agreement, it is very important to not give preferential treatment to a particular carrier. If a particular carrier says that they basically own all of the public rights of ways, as well as the poles that are private property, and have the ability to destroy them or change them and do anything that they want with them, that could potentially conflict with the Telecommunications Act to treat all carriers in a fair and competitive manner. Because if there are other carriers that are coming in that want to come in and also provide good service to your locality, you don't want to be perceived under the law as providing preferential treatment, first of all. And secondly, if there is an agreement with any locality, the locality must have the right to terminate. It should not automatically renew. It must have the locality must have the right to terminate the agreement, particularly if the service is poor or the emissions exceed FCC standards, because that is also another way that providers want to have more power than the Telecommunications Act gives them. And remember, you do not want to give up your local rights under the Telecommunications Act that the telecommunications is due by contract.
By contract. Got it. Odette, God bless you. I so appreciate you. Thank you for taking time out. I feel like, since I've been in Endicott, I feel like the state of New York just treats Endicott as just a dumping ground for, leachate dumping and for, we call them stink trucks that were coming here with this ultra high concentrated leachate. And now we've got battery incinerators, and now we've got this stuff. So to have somebody of your stature and your caliber and your legal knowledge and your expertise to helping out little old Endicott, I am just so grateful for your care and your concern. And I don't know how to express it any more than that. I'm very, very grateful for this call and this conversation, Odette. Thank you.
Thank you so much, Bill, for having me. It was a pleasure.
Okay, so I'll talk to you later.
Okay, bye.
Bye. Okay, friends, that was it. That was the big show. And I just want to say, that I work in the public interest. I have for really 20 years, but I've done I've got a very serious, strong track record for the last 10 years, locally and regionally, fighting fracking, pipelines, compressor stations, bomb trucks, leachate dumping, battery incinerators, and now 5G. So I really need to raise $2,500 very urgently. Okay, very, very urgently. So if you appreciate my work, I would give you my post office box, but I'm presently locked out of my post office. Okay, that's how backwards I am in my finances right now. I really live on donations and grants, and my donations have been way off during this COVID. So I know everybody's financially strapped right now, but there are some people that do have money. So I'm reaching out especially to major donors, but I'm grateful for $5. I have gotten $5 donations. I'm grateful for every single donation, and I'm very, very appreciative to everybody that has supported me over these years. I really need $2,500 very, very urgently, very, very soon. So now is the time to donate if you haven't donated before, or if you're I hate to keep hitting up the same regular donors. I've got some regular donors. I'm very, very appreciative. I don't know if I should even say your names or not, but people have said sometimes they want to be anonymous. I'm grateful to everyone that has ever donated to me over the past 10 years or so. So tinyurl.com, donate to Bill Houston. That is the link to go to. You can actually go to the video description down below, and you're going to see a link that you can click on. That is my donate link. I cannot accept mail donations at this time until I pay off my post office box, okay? So please, if you can, $100 donations, $200 donations. If you're capable of doing a $500 donation, major donations are going to be super helpful for me right now. But I'm not going to turn away a $5 donation or a $20 donation. I work in the public interest, and I'm doing work that nobody else is doing. The environmental regulators aren't doing it. We already talked about that before, like with 5G. It's like with the federal environmental regulators aren't doing it. They're all taking a pass. The state environmental regulators are all taking a pass. That's what we had with fracking. That's what we had with bomb trucks. Over and over again, that's what we see. And by the way, the big NGOs like taking credit for the work of people that are working on the front lines like me, frontline environmental activists. But we are the ones that are way out ahead. I don't see any, I have friends and supporters that are in the local Sierra Club, but I don't see the Sierra Club taking a lead on any of these issues. I'm sad to say. I wish they did. If they were taking a lead, I could be doing something else with my life. I could be, practicing my guitar lessons or something like that. I could be riding, taking long bike rides. Nobody is doing this work that I'm doing, friends. So I hope that people recognize that my leadership on as an environmental activist and taking on these, and I put my body on the line. I've been arrested for protests, for blockades at Seneca Lake. I was arrested, and also, I was dragged through the courts for 2 years. And let me tell you something, when they want your ass for discovery, that's what they said, we want discovery, which means they basically want access to all kinds of personal files and personal records, computer data. It was hell. I have lived through hell getting dragged through the courts by a big multi-billion, like a $12 billion oil and gas company. Okay. I put my life on the line for this work. If you appreciate me, and if you appreciate the work that I do, and if you can see the vital nature of the work that I have done for 10 years, for really 20 years, if you go back and look at the media work, the media reform work that I did in the 2000s, and also working with anti-war efforts in the 2000s, I have worked in the public interest for 20 years, friends. So I need your help more than ever right now. There's the donate link, tinyurl.com/donate to Bill Houston. And so that's it. I'm going to wrap up the show. Let me do a quick check of the chat. There's nothing else in the chat. It looks like a lot of people have dropped off already. So there it is. Be sure to like this video, share it out. Don't forget to subscribe to the Bill Houston Podcast on YouTube. Also, find me on BitChute, because I'm starting to get censored by YouTube. Okay, I don't know how long I'm going to be able to continue doing these broadcasts on YouTube. So please find me on BitChute and subscribe to me there too. And you can find a video that I did about the pandemic that was censored by YouTube. Thank you so much. I appreciate my friends and my donors so very much. And I will talk to you later. Bye-bye.